Excuse me. Good morning, members of the tribunal and council. I believe we have the tribunal connected, and I see counsel from claimants and the respondent connected. Mr. President, we are ready to begin day 6.
You're on mute, sir, unfortunately. Yes.
Good morning, Mr. Carley and Mr. Hill. Can you now hear me?
Yes, Your Honor.
The tribunal has been debating the claimant's request to introduce an additional letter and the respondent's response to this, seeking in their turn to introduce a further letter should the claimant's request be granted. And we would propose, subject to hearing any objection from counsel, that both of these letters should be placed on the record without prejudice to the question of whether they are relevant. I see Mr. Hill nodding.
Yes, we're content with that. We're content.
Yes.
Your Honor, may I ask for a slight modification of that? Can we ask that they be put on the record subject to a discussion, if there's time, in this hearing as to the differences we perceive as to the grounds on which these two requests are made, such that it may be subject to being strict, one or both may be subject to being stricken. In other words, not a final decision to admit and revisit the issue if there's a difference, but not take up that time right now?
I'm not minded to do that. If they're placed on the record without prejudice to the question of whether they are relevant. If they're not relevant, they will carry no weight whatsoever, and it will be as if they were not on the record. But we can defer that discussion to later. But Mr. Cowley, there's one matter I would like a little assistance with. As I understand what you told me when Mr. Bodega had ceased giving his evidence, was that his statement was prepared with assistance from Mr. Ramasirabo. Is that right?
Mr. Ramasirabo assisted us in setting up a discussion with him. I believe it was, as I understand it, as I wasn't on the initial discussions with regard to the drafting of a witness statement, that they were in his office. If they were not in his office, that they were set up by Mr. Ramasirabo wherever they occurred. He was present to help explain what we were saying and explain to us what Mr. Bodega was saying. But then we took to try to write it up, submit it to him so he could understand it. And we were told by Mr. Ramasirabo that he read it to him, told him what it said, but then turned it over to him and his son, who speaks English, and his son and he went through it, and whatever edits they had or changes they had before coming back to us were made. So we did not, we were not in the active discussion in which he signed it. It was he and his son at least sitting down and going over it.
Well, what I particularly wanted to ask you about was the position of Mr. Ramasirabo, because we have had put on the record a declaration from him, and he declares, "I am independent of the parties, their counsel, and the tribunal." And the tribunal would just like to know precisely what role he has been playing in these proceedings and the basis on which he is retained.
We have not retained him, and I don't have any more information about it than that. Mr. Ramasirabo, for the purposes of Mr. Bodega's witness statement, and then later the conversation which I was involved in, the preparation for this hearing, going over the details of how it would happen, I know set up the discussion, contacted Mr. Bodega to bring him into the discussion with us. I thought it was in his office, so he was playing a facilitator to make sure that the conversation could happen, and was there to answer any questions about the interpretation. We had to make sure he understood what we were saying, and Mr. Ramasirabo was there. But that it wasn't anything more than in that instance, it wasn't anything more than, for lack of a better term, an informal interpreter, making sure he understood what we were telling him, timing what we were doing, making sure he had copies of his witness statement. And we went through Mr. Ramaswarabo's communication. I believe it was in his office, a Zoom meeting. So that's the role that I know he played with this, a facilitator.
Should we leave it there for the moment? Leave it there. Well, thank you. We'll leave that there for the moment.
Mr. President, could I just pick up on one part of the answer from Mr. Cowley, where he said that, as I understood, his firm haven't retained Mr. Ramaswarabo. Yes. We are still rather perplexed about whether he is or is not being presented as essentially an expert witness in these proceedings. It seems becoming more confusing as a result of that answer. And I wonder if Mr. Cowley could be clear whether he is purported to be an expert in these proceedings or not.
Shall I respond, Your Honor?
Yes, please.
The discussions happened long before Mr. Hill became involved, and they haven't changed because we've never discussed any open issues. But the issue was raised initially by a challenge to us whether we could submit the second witness statement of Mr. Ramaswarabo, and a position was taken that he would need to be an expert. It wasn't accepted that we could submit the witness statement. So we began a discussion that if we disagreed, we explained our position. We did not believe, we hadn't retained him as an expert. He was not opining as to the law. He was defending himself against he was defending his initial statement as to what he did, what he analyzed, and his work with the claimant that did not go forward. He wasn't retained to bring a case in Rwanda. So he wasn't working and hired in that capacity, but he did review the file, and he's someone who has the practical experience of representing other concession holders. So that's how NRD came to initially contact him. They did not go forward with him, and he provided a witness statement as to what he's had in his file with regard to NRD's application and his own experience as to how the concession process works. He's talking about his practical experience. So we said he was a fact witness, and if challenged in terms of his statements as to what he does and how he works with concession holders and what they do, what they expect, on the idea that he has misunderstood the law or doesn't appreciate the law, he's perfectly free to explain his understanding of the law, and he doesn't need to be an expert. And Respondents Counsel said no, they disagreed. So we said, well, then we're prepared to engage him as an expert, and we gave him a statement that he was prepared to go forward in that capacity. And we asked them, let's have a discussion. We think he can do what he's done just as a fact witness. If you disagree, we gave them the materials that they said were lacking for an expert. We said we could discuss you having more time, us going back and redoing and engaging him fully as an expert to analyze the law more broadly than the narrow issues he discussed. And we never picked up the discussion ever. So it was just left as an open issue. And we were waiting to see if they were going to go forward with a challenge to his witness statements. As it came to be, when we had the initial hearings in this case, there was no further, the scheduling hearings before this proceeding. That was one of the open issues because it was never discussed again. And we heard at that time that the respondent did not have any concern about putting him at the end, leaving him in a position to possibly testify as to opinion, but I guess they were still reserving the argument as to what capacity he would be in. And then we heard from Mr. Hill in answer to your question, whether there's anything that hinges on the designation of him being an expert. The answer that we suspected was true all along, which is nothing. We weren't proposing anything more than the witness statements we submitted. They weren't actually proposing to go forward with trying to strike them. So nothing hinges on it. He's simply testifying, and that we don't intend him to do anything more than testify like any fact witness when it comes to cross-examination. He will be cross-examined on his witness statement. That's all we intend, and that's all we ever intended, but we never had that discussion not because we've been unclear about it, but because it simply has never been picked up again. We invited the discussion and got no response. We're happy to just leave it that he's got witness statements on file and will testify like any other fact witness in examination of them. And we're not asking for anything more. We did not have him sit through the hearings and listen as experts are allowed. We're not proposing to have him make a presentation on his own. We didn't ask for any of those things.
Well, I'm grateful for the clarification, and I've just put down my marker on. In light of that, Mr. Cowley has confirmed he is put forward as a factual witness. We will be saying he doesn't really have any relevant, admissible factual evidence he can give, and he's not being tendered as an expert. And that would also mean he doesn't have any evidence in which he can really assist this tribunal. But I just put down that marker.
Yes, you put down the marker. So far as the tribunal is concerned, we agreed that his evidence would be called because there was no issue as to that. When a witness gives evidence, there's always the opportunity for counsel to challenge the admissibility or the relevance of the evidence given. When we come to that evidence, then there may be challenges to it on the basis that it is irrelevant. But having looked at the evidence, it did seem to the tribunal that some of it was evidence of law. So if one's trying to categorize his statement, it seems to the tribunal that it is at least in part expert evidence of Rwandan law. And the tribunal wouldn't wish to shut that out on the technical ground that he's being called as a witness of fact and not as a witness of law. So let us proceed.
May I ask, Mr. Kaplan, is Mr. Ellers available now? Is that who the next witness is?
Ellers is in the waiting room, and it sounds like we're ready to bring him in to continue.
May I have just 2 minutes, because when we were informed that he wasn't available, I brought up all the exhibits on my laptop for the other witness. So let me just bring the right ones
All right,
up.
put your house in order.
FTI, I do see him in the waiting room, so please confirm.
I see him, and he is in the waiting room. We had brought him in and tested his connection and put him back in the waiting room. So I'll wait to bring him in.
Let's bring him in, please.
Okay, bringing him in now.
Good morning.
Good morning,
Good
Mr.
afternoon,
Ehlers.
sorry.
Can you hear us, Mr. Ehlers?
Yes, I can hear you.
Excellent.
Can you hear me?
We can hear you well, sir.
Thank you, fine. Thank you.
Thank you for that opportunity to get the right exhibits up on my computer. I'm ready to go forward.
Good
Yes.
afternoon.
Good afternoon, Mr. Ellers. In 2011, shortly after being terminated by NRD's new owners, you immediately began working on a application to obtain one of their concessions out from under them, correct?
That's correct.
And the entity that you worked through or under the name of was Mountain Valley Mining, is that correct?
That's correct. It's an Australian company.
And the concession that you went after to try to get away from NRD was the NEMA concession, is that correct?
That's correct.
If I could ask FTI to bring up exhibit C181. And as a result of the efforts you made with Mountain Valley Mining to pursue the NEMBA, excuse me, let me restate the question I started. As part of the efforts you made with Mountain Valley Mining to go after NRD's NEMBA concession, you submitted on June 13, 2011, an application for that concession, correct?
Correct.
Now, at this time, the Ministry of Mines had not publicly announced that they were accepting applications from others for the award of the NEMBA concession, correct?
I'd heard very strong rumors and I wanted to put us on the list.
In fact, you were creating the rumors, correct?
I beg your pardon.
You were creating the
Please,
rumors, correct?
sorry, you're breaking up. I was doing what?
You were creating the rumors that NRD was in trouble with the NEMBA concession, correct?
Not at all.
You will agree that you did not respond to a public announcement of that the ministry was accepting applications for a NEMBA concession, correct?
No, I didn't respond to a public announcement.
And the application that's attached to this cover letter, you prepared, correct?
Yes,
And
I
you-
submitted it.
You prepared the application for the allocation of NEMBA vast mining and exploration license to MVM. You prepared that document, correct?
Yes,
And to do so, you relied on the information, data and documents on your laptop that you have been holding since leaving NRD, correct?
yes, correct.
And you admit that you knew it was NRD's information that you were using, correct?
Yes,
And in your second supplemental witness statement, if I could ask that FTI bring that up as well and focus specifically on paragraph 33. In this paragraph, you explain that if I could draw your attention to the last sentence of the paragraph, that you accept that it may have been wrong to use that information, to use NRD's information for the purpose of submitting an application for a concession owned by NRD. You acknowledge that, right?
yes, I do.
But you justify it by saying you thought you were owed money, so it was appropriate, correct? Mr. Ellers, did you
Did you
hear?
hear me?
I didn't hear an answer, so let me
I
ask
heard
the
you.
question again. Can I ask the question again so it's clear that what you're answering?
Yes, sure, sure.
You justify using the NRD data and information on your laptop in order to pursue an application to get one of the concessions out from under NRD because you say you were owed money by NRD and you felt aggrieved by how Mr. Marshall treated you, correct?
Yes, that's correct.
And you admit that as of this time, as of June 2011, you hadn't filed a claim for unpaid wages in any court proceeding in Rwanda, correct?
My wages or my salary, I never had to ever submit a invoice. It was paid automatically into my bank account. But I'm not quite sure exactly when I started action against NRD, but it must be around, I'm sure I'd started the action long before that.
You'll agree that you don't present any evidence of an action against NRD in your witness statements, correct?
Yes, I don't have evidence of that.
And you'll agree, won't you, that the value of whatever wages weren't paid for a month or so that you say the money didn't go into your bank account pales in comparison to the value of owning the license rights to the NEMBA concession, don't you?
Yes, that's correct.
And because your focus immediately upon being terminated, and if I could ask FTI to, you could close the witness statement document, and if you bring up C-181, just so that the witness can look at it if he needs to refer to it. I don't have a specific question. You'll agree that because your attention was turned almost immediately upon termination to preparing a document, that document, C-181, the application for allocation of NEMBA vast mining and exploration license, that in order to give that application any meaning, in order to get in line or put your name in, as you suggested earlier, you needed to create vulnerability for NRD's continued holding of the NEMBA concession, right?
Sorry, I'm not following you. What do you mean by vulnerability?
You needed to create the rumors and questions about whether NRD was going to be able to hold the NEMBA concession because you wanted to get it, correct?
Yes, I wanted it, but I didn't have any need to create rumors.
Well, you'll agree, sir, that while you were managing, let's take a step back. The status in June 2011 was that NRD had pending with the Ministry of Mines a application for concessions the licenses going forward in both the, in the NEMBA concession and the 4 others that NRD was originally awarded, correct?
Correct.
And that application was submitted in November 2010, correct?
Correct.
At the time, in November 2010, you were the managing director of NRD, correct?
That's correct.
And you had no hint that you were going to be fired in a few months, correct?
Yes, correct.
Mr. Marshall wasn't even owner or engaged at that time in the sale transaction, correct?
That's correct.
You oversaw the preparation of the November 2010 application, correct?
That's correct.
And when you did that, you didn't say to the Ministry of Mines, we concede that we're not entitled to concessions going forward, or licenses going forward, excuse me, for these concessions. Did you?
Just repeat that, please. You broke up a bit.
Sorry. When you were managing director of NRD and overseeing the submission of the November 2010 application, you didn't communicate to the Ministry of Mines on behalf of NRD, we concede that were not entitled to licenses going forward, did you?
No, I did not.
Your position was, as managing director of NRD, that the application you were submitting was sufficient to be awarded the licenses going forward for those 5 concessions, correct?
No, that's not correct. Very soon after I submitted that application, I had a meeting with Dr. Michael from OGMR, and he told me that NRD had not done enough exploration, and there was still a lot of work required.
And if that happened,
A lot of
you
work,
would have, I'm sorry, I didn't know you were still talking, sorry.
yeah, there was a lot more work required, and the environmental impact assessment had not been completed, if I remember correctly.
Well,
So Dr. Michael specifically asked me to finish the EIA, but the company had not done sufficient exploration, according to Dr. Michael.
if that had happened, we'll strike the question I started. The time of this conversation, you were still managing director of NRD, you said, correct?
That's correct.
You reported to the owner of the holding company, which was a Stark subsidiary, correct?
Correct.
So the people who were paying you were at Stark, and they expected you to carry out and protect their interests in their investment in Rwanda through NRD, correct? I believe we may have lost. I'm sorry, sir, but if you answered, it was all lost in terms of the audio transcript. So I'm going to ask the question again.
Okay. Yes, it's correct. I was, as MD, I was still looking after, Stark's interests.
So you
But
knew
after my meeting with Dr. Michael, I immediately spoke to Stark and explained to them that not sufficient exploration had been done.
you've not produced any document from your laptop supporting the idea that there were communications between you and Stark after November 10, 2010, in which you reported on the so-called discussion with Dr. Mike, correct?
Yes, that laptop has been stolen a long time ago. It was stolen out of my car. So I don't have that information, but that type of communication would have been telephonic and in writing.
And you never produced a copy of the writing from whatever source in which you were supposed to have told Stark about a meeting you had with Dr. Mike, correct?
Yes, because I don't have that information. Can I carry on?
Well, I have to ask another question. I'm sorry.
Sure.
I was going to ask another question. Now, go forward.
Yeah, sure. I'm listening.
You submitted the application on behalf of Mountain Valley Mining that's been marked C-181 based solely on the information on your laptop that you had to use for the NRD application in November 2010, correct?
Correct.
So your testimony is that after submitting the application for NRD, you were told that the data provided did not show sufficient exploration. And yet you submitted the same data again in June 2011, expecting to receive the concession on behalf of another company, correct?
Yes, but we were prepared to do the exploration which was required.
But you hadn't done any exploration between getting fired by Mr. Marshall and submitting the June 2011 application on behalf of Mountain Valley Mining, correct?
That's correct. There was no way that I could go and explore or do drilling on that concession.
And you couldn't go and do an environmental impact assessment on the NEMBA concession either, correct?
No, I can't remember exactly when we started the environmental work. I can't remember, but yeah.
But NRD didn't give you
It
access.
was, NRD did not give me access.
Sir, I just want to apologize for speaking over you and try to explain it in case it helps us to
No,
avoid it.
I'm listening. We are breaking up a bit.
That's the problem. So if I do start talking over you, I apologize. I will try to stop and have you pick back up what you were talking about. Just let me know.
Sure.
You'll agree that you had no access to the NEMBA concession after being terminated and before submitting the application on Mountain Valley Mining to improve on any aspect of the data or information that was included in the November 2010 application for NRD, correct?
That's correct.
But you thought that same data information in June 2011 was good enough to get the NEMBA concession awarded to you on behalf of Mountain Valley Mining.
I think yes.
And isn't it true that your discussion?
I
apologize.
I'm listening.
I think I cut off what you had to say, so I'm sorry, sir, but I don't think if you did say something, it's recorded.
No, that's right. You carry on. I can add.
So isn't it true that your discussion with Dr. Mike was not about things that needed to be improved on for NRD, but how you and he could work together so that the concession could be taken from NRD and given to a company you controlled?
No, I never had any of that discussion of that nature with Dr. Michael. I don't know who has met Dr. Michael, but Dr. Michael is a very, very honorable man. And Rwanda isn't a country where the head of geology would be giving away tenders or be giving away concessions based on some underhand dealings. Dr. Michael, that is not Dr. Michael's character. And in Rwanda, if you had to do that, you would end up in jail very, very quickly. It is a country with zero corruption, or perhaps one of the less corrupt countries in Africa. No, I never had any discussion of that nature with Dr. Michael.
So you've seen the information and exhibits that were put forward by respondent, or at least you've seen some of the exhibits and information that have been put forward by respondent that relate to you, and you use some of them or refer to some of them in doing your witness statements in this case, correct?
Yes.
And you've never seen from the respondent any document from Dr. Mike internally or externally to NRD or someone else, memorializing a conversation he had with you about the things that needed to be improved upon after the November 2010 submission of the application, correct?
We had a verbal discussion on that, but I didn't see any more documentation.
And you'll agree with me that based on your work with respondent to prepare your witness statements, it's fair to expect if Rwanda actually had a document memorializing such a conversation from Dr. Mike's side, it would be part of your witness statement, wouldn't it?
Could you repeat that, please?
You'll agree that based on working with the respondent to prepare your witness statements, you would have expected if there was a document confirming the discussion you say you had with Dr. Mike after November 10, Rwanda would have put it, the respondent would have put it as an exhibit to your witness statement, correct?
Well, I can't say what they would have done, but I didn't know of any document like that. I still don't remember a document like that.
If I could ask on if you scroll, I'm sorry, it's the document on the left, and because he's on a laptop, because he's on an iPad, if we can make it just one page so that it's big enough for him to see. So this is the transmittal letter, sir. The CC, is that intended to read head of, well, you tell me, what does the CC refer to? Who did you deliver the copy to?
That HOD would have been the HOD in the Department of Geology and Mines.
And what did you understand that to refer to when you sent this?
I would have understood it to refer to Dr. Michael.
You, in fact, worked with Dr. Michael in preparing this application before it was sent, didn't you?
No, I did not. No, I never worked with Dr. Michael.
If I could ask that C122 be brought up. You were informed that as part of its submission, claimants, as part of their submission, I should say, claimants provided this document, a cooperation agreement between BVG when it was independent of NRD and NRD from the 2010 time period, correct?
Yes.
And you worked with respondent and you prepared a witness statement that said you're not aware of any such document, not your signature, not aware that any cooperation agreement existed at all, correct?
That's correct. It's a long time ago and I couldn't remember that we had a agreement in place.
In fact,
what I did say in my statement is that Mr. Marshall and I had discussed it in November. And that's it. We had discussed it. I couldn't remember signing a document.
If I could ask that Mr. Eller's supplemental witness statement be brought up and paragraph 23.1 be focused on. So in fact, the first thing you said when informed of the document we just looked at is in paragraph 23.1, correct?
Correct.
And you said that you never saw a written cooperation agreement before at all, correct?
That's correct.
That you had discussions, but you didn't mean to say you had discussions about a document in your answer just a moment ago, right? You meant to say in this witness statement, you didn't believe there was such a document ever prepared. Isn't that correct?
That's correct. I couldn't remember a document being prepared.
And that's because you want very much to call Mr. Marshall a liar, don't you?
No, I have no reason to call him a liar. If he's not telling the truth, it'll come out in his witness statement.
And then if I could ask that C210 be brought up. I'm sorry, C210.
Just one moment.
You were made aware, sir, that after you submitted your supplemental witness statement, the claimants in response provided a copy of this email and its attachment, if you could scroll down so the witness can see. Is not one document. Can I ask that the email be scrolled down so that the attachment can be brought up? So you were aware that the next thing that happened relating to a cooperation agreement was that claimants responded with a version of such an agreement that you signed and sent by email to Mr. Marshall, asking him to countersign and send back, correct?
Yes, I didn't remember that, but after I've seen this, that's correct.
And as a result of seeing this, you went further to ask to see the metadata because you questioned the truth of the email and whether that was faked. Isn't that right?
Could you repeat it, please?
Yeah, as a result of learning that this document was presented, you challenged whether this document, the email and its attachment, was legitimate, and you asked to review the metadata, the computer information about this document, didn't you?
Yes, because I had no recollection of signing this document.
And you were
And I had no recollection that we'd set out these points.
you were looking for another way to call Mr. Marshall a liar. You were trying to challenge the veracity of what he represented, correct?
No, I certainly wasn't doing that. I just didn't recall signing this. I didn't recall this document. So I think that's
And
reasonable to say. If you don't recall it, you'd like to say, well, show me.
And claimants did show you the metadata, correct?
No, I didn't see any metadata. I saw this.
You know the claimants provided metadata to the respondent's counsel, don't you?
Possibly they could have. I didn't see it.
You've not reviewed metadata and have any challenge to the information in such metadata as to when this document was sent and by whom, correct?
Yes, I have not had access to that.
You'll agree, sir.
I do.
I'm sorry, I didn't mean to speak over you, please.
No, sorry, I'm listening.
Okay. You'll agree, won't you, that in November 2010, you had a better memory of what discussions you were having with the then third party, BVG and Mr. Marshall at that time than you do today, correct?
Yes.
You were paying attention to this.
Some things stick out in your memory.
No,
Some don't.
I understand that. I'm moving on. I'm suggesting focus. I want you to focus back in November 2010. This was something that you were focusing on getting done with Mr. Marshall on behalf of Stark and NRD. You were involved, correct?
That's correct.
Okay. And so at that time, you were aware, better than you are today, of what was agreed to and what was supposed to be done, correct?
Yes.
And you'll agree, sir, that
I would just could ask Mr. Kelly just to give him a chance to give his answer, because there you are cutting him off a little.
apologize. I'm just trying to speed up, and I agree, Mr. Ehlers. I'm not trying to cut you off. So please, if I did prevent you from saying anything, please finish.
No, I understand. We've got time lag, and I understand perfectly.
You'll agree, sir, given your role as managing director and whose interests you were looking out for at the time, if BVG did not provide the $100,000, you would have called them out on it and demanded that they perform, wouldn't you?
Yes, I would have.
And you've provided no such documentation in connection with your witness statements, correct?
Correct.
No further questions.
Mr. Ehlers, just on the last point, do you recall under the agreement that the $100,000 was there as a loan to provide to NRD for purchasing equipment to be used for the work that NRD was to do on the Bisesero concession?
That's correct.
Now, did NRD do work or not do work on the Bisesero concession for under this cooperation agreement?
As far as I remember, NRD never did any work on Bisesero.
But
These things, the company was bought by Mr. Marshall at the end of December, a month later, you could almost say. So there was never any work done at Bisesero that I remember.
So in those circumstances, do you think it would have been necessary or not necessary to bother to chase for the $100,000 for equipment for that work?
Yes, what I envisaged with that 100,000 was more like site establishment. We had the equipment in NRD, which we were not using fully, but we had to hire low beds and trailers for transport, and we would have to establish ourselves on Bisesero. It was more like a site establishment, I envisaged it.
Thank you, Mr. Ehlers.
Thank you very much, Mr. Ehlers, for coming to assist us. You're now free to go.
Thank you very much.
We now have Mr. Unsengi Yuma.
Yes, I understand he will be giving his evidence in French. Is that right?
Just a reminder for everyone to choose the proper interpretation channel. If obviously English, if you're a native English speaker. And would you like me to bring him in, Mr. President?
Yes, yes, please.
I believe they are going to get him from his personal waiting room.
Right.
Mr. Insiaguma, you should hear me interpreted on the French channel. Is that correct?
Oui, je vous entends très bien.
Yes, I received the French translation loud and clear.
Excellent. Okay, Mr. President, we are good to go.
Thank you very much. Good morning, and thank you for coming to give evidence today.
Bonjour.
You will see
Merci
on the
de m'avoir
screen a déclaration du témoin. Would you please read it?
Vous dites?
On the screen in front of you, do you see a déclaration?
Je lis?
Could you please read it
OK.
aloud?
Déclaration du témoin.
Witness statement, I solemnly swear on my honor and conscience to speak the truth, whole truth, and nothing but the truth.
Thank you.
Merci.
Mr.
Thank you.
Nsingiyuma, could you be shown paragraph 8 of your supplemental witness statement, your second witness statement? Now, I understand you have a correction or amendment you would like to make to that paragraph.
Oui, j'aimerais bien.
Indeed, I would like to make a change on the second line. I passed on my communications to the head of SPIDAG for her to pass them on to Mrs. Susanna Mrusko-Vikova. Ever since the first contact with Susanna and Macho, they had refused to speak to me directly. And every time I had to go through a third party who would then pass on my message, or Mrs. Muskova would go through a third party who then would pass on her message. So there was no direct contact. There was always a third party in between. That was our work environment.
Now, you explain in your witness statements that you were executing on certain judgments. One of the questions that has come up in this case is whether or not you provided copies of those judgments to NRD or to Mr. Marshall or to Ms. Moroskovikova. Can you just give your evidence on that question?
La transmission de mes documents était toujours par le canal.
I passed on my documents through the reception of the NRD office. They had a secretary there whose name was Barbara, and she would take in all the mail. Now, under Rwandan law, the bailiff is expected to leave the document with the secretariat of the company. There's no direct contact with the executives of the company.
Now, thank you, Mr. Nsengiyuma. Mr. Cowley, who represents the claimants, will now ask you some questions.
Merci.
Thank you.
Mr. Nsengiyuma, I'm sorry if I mispronounce your name during the course of this questioning. It won't be intentional, but I seem to unintentionally do that a lot, and I apologize in advance. A professional bailiff
No, pas de
in
problème.
Rwanda is required to maintain an accounting of the value of recoveries received after seizure of property against debt being enforced, correct?
Correct.
That's correct.
A professional bailiff in Rwanda is required to maintain a log identifying all property seized or locked up for collection against the debt, correct?
Correct.
It is true. It is correct.
A professional bailiff in Rwanda is required to maintain the security of property seized or locked up before it could be safely disposed of and credited against the debt, correct?
Correct.
That's correct.
Professional bailiff in Rwanda is required to obtain independent appraisals of value for the property seized before selling it, correct?
Oui, correct.
That's correct too.
A professional bailiff in Rwanda is required to report back to the court as to the results of any court-ordered or permitted auction of seized assets to inform the court what was obtained or other results of the auction, correct?
Le huissier de justice.
Well, the bailiff does not report to the court. The law says that you have to report to the person who gave you the order. You have to provide the copy of the judgment, of the ruling, and should the person or the company disagree with what was done, well, that company or the person can turn to court or to the police. And that was the case with Mr. Marshall and Susanna. Whenever there was an auction, the police was involved, and I had to go to the police and explain myself.
in the situations where a professional bailiff in Rwanda seeks approval of a court or permission from a court to hold a specific auction of specific property, it's that bailiff is then required to report back to that court as to the results of that auction, correct?
Non, le huissier, la loi rwandaise.
No, the Rwandan law, when you have to seize property, the mechanism is as follows. The client comes with a copy of the ruling with a command from the court. Now, there's a contract between the person who provided a copy of the judgment and the bailiff.
Mr. Guillaume, excuse me. I just would like you to focus on one incident and one aspect only in my question. I appreciate that there's more to the work of a bailiff on collecting on any debt than I'm specifically asking about now. But I ask you to focus only on one instance, one circumstance that might come up. And that is a situation where, while working to collect debt, a bailiff in Rwanda, for some reason, asks for and obtains permission of the court to hold a specific auction. In that instance, the bailiff is required to report back to that court that gave the permission as to the results of that auction, correct?
Le huissier de justice ne demande pas l'autorisation au
Well, the
tribunal.
bailiff doesn't request authorization from the court. He simply publishes dispatches, that is, announcements on the media, in papers, on radio, and on the indicated dates, he acts upon the order. That's the way it works.
Professional bailiff in Rwanda is required to provide a written report to the judgment debtor as to the status of all credits, all receipts obtained from the seizure and sale of assets taken from that debtor, correct?
Il fait le débiteur et le créancier.
Well, yes, to the debtor and the creditor.
Now, you provided an initial witness statement in this case. If I could ask that be brought up, we're going to refer to it at points. And through the course of this witness statement, you discuss events relating to your seizure and auction of minerals tagged in NRD's name at the entity called Mineral Supply Africa, in order to collect on a judgment in favor of your then client, Pascal Rakir Renga. And I'm sure I mispronounced his name and I apologize to him. Is that correct?
Je me rappelle du cas.
Yes, I recollect the case.
In collecting on that debt, and if you'll permit me, I would like to refer to that client of yours as Mr. Pascal. I'll be less likely to mispronounce that. In collecting on Mr. Pascal's debt, you also seized other assets of NRD beyond those minerals you refer to in this witness statement, correct?
Il y a eu uniquement.
Well, there were only two auctions conducted by myself. Now, other property was seized by other bailiffs, but I myself only conducted two auctions. So there were the minerals to MSA and Mr. Marshall's car, and other bailiffs were involved in selling other things, but I only conducted these two auctions.
And Mr. Marshall's car was seized and auctioned in what year?
Non, je me rappelle pas l'année, mais dans les
I'm
documents.
afraid I don't recollect the year, but it must be in the documents.
You seized a number of other assets from NRD, including trucks, heavy equipment, machine equipment, correct?
Ce que j'avais saisi,
What I seized at a certain time,
Marshall a porté plainte
Mr. Marshall lodged a complaint with the Ministry of Justice,
prétendant que
claiming
je fais
that
utilise des documents de tribunal
I was using
falsifiés.
forged or falsified
Le ministre de la Justice
court documents, and the Minister of Justice at the time ordered me, in fact, to put an end, to put a hold to what I was supposed to do, that is the execution against the NRD, and asked me to leave that case. So I did so.
J'ai quitté dans ce dossier de NRD,
And so when I left the file,
collègue huissier
my bailiff colleagues took over the self-same case, and they continued the work I was supposed to do.
And you're talking about the collection case for Mr. Pascal, correct?
j'avais 28 personnes, 28
Well,
je crois.
there were as many as 28 NRD employees who hadn't been paid their wages. This was unlawful termination, and so this entire group of NRD workers, I think there were 28 of them. The exact number is in the document. Pascal was just one of them. He was one of these terminated employees.
And I would like to focus on that case and that collection effort for that client. You seized a number of assets in order to collect on behalf of Mr. Pascal. I'm not asking about the others yet, correct?
OK.
All right.
And you say included among the assets you seized to collect for Mr. Pascal was Mr. Marshall's car, correct?
Il y avait d'abord
Well, first, there were the minerals, which were located at
c'était la première saisie.
IPC. This was the first seizure.
Et c'était Pascal qui en a bénéficié.
And
indeed, it was Pascal who was able to benefit from the proceeds of that.
My question was about the car. You mentioned when we talked about the minerals and I said, other than the minerals, you seized other assets. You brought up Mr. Marshall's car. I'm trying to confirm with you that you brought up Mr. Marshall's car as another asset you seized in order to collect on behalf of Mr. Pascal, correct?
Pascal et les autres.
Well, not just Pascal, it was Pascal and other workers.
Well, whose debt did you credit the sale price of the car against?
Une partie, c'était Pascal.
Well, part of it was indeed for Pascal.
Okay, let's appreciate. Let me walk through a little bit more.
C'est Pascal qui a tout récupéré.
But for the minerals, that went all to Pascal.
I'm gonna possibly return to that question about the distinction, but let me take it in order of your witness statement. It might be easier for you to follow my questions if you have your own witness statement to track along with. Can I ask FTI to focus on paragraph 10? in this paragraph of your initial witness statement, you discuss the first efforts to collect on behalf of Mr. Pascal, correct?
Il y a quelqu'un qui peut traduire en français?
Apparently, he didn't receive the translation. I'll start again.
La traduction en français.
Could we have the, apparently, Ms. Nsinguma didn't receive the translation. Can we try again? Can you ask the question again, please?
Oh, ask me. I'm sorry. Of course you are. Paragraph 10 of your witness statement, sir, is the discussion of your first efforts taken on behalf of Mr. Pascal to collect his alleged debt against NRD.
Okay, oui.
That's correct, yes.
And in this paragraph, well, to be clear now, because I did bring up the topic of distinguishing between the two. At this time, whatever number of the other clients you characterized sometimes as 26, sometimes as 28 in your documents, that hadn't started yet at all. At this time, the only debt you were collecting against NRD was Mr. Pascal, correct?
Il faut regarder l'année.
Well, you have to look at the year. Here, we're looking at 2013. 2013 was indeed the first order I executed. But after 2013, other employees came forward.
So we can agree that at the time referenced in paragraph 10, the only client you were working to collect debt on, against NRD was Mr. Pascal and no one else at that time, correct?
Ici, c'était Pascal.
That's correct, it was Pascal.
And you say that you served notice of the debt you were going to collect on so that NRD could pay in order to avoid your seizing assets. Say that in paragraph 10, right?
Allô? Il n'y a pas de traduction.
The witness is not hearing the translation, the interpretation.
I know, Mr. President, that I've gone past 8:15, and if memory serves, that was the time for the
Au
break.
niveau de la
So
procédure,
perhaps-
If I may answer, he says, when you pass on copies of the judgment to NRD, the company is required or is requested to pay, to come up and settle the debt. And if it doesn't do so voluntarily, well, then the property is seized and auctioned off.
Mr. President, is this a good time for the tribunal to take a break?
I don't think it is, because we only have the interpreter for the first 3 hours of this day. So I would propose we continue until this witness is finished before we break. Having regard to your estimate of the time you would need, I imagine that's likely to be before 2 o'clock.
pas de problème.
There's no problem on our side, says John Buss, says the witness.
Now, your witness statement cites in support of your statement that you provided notice of the amount to be paid. You cite to R51, a document with the number R51. Do you see that?
Il y a un document que vous aviez passé tout à l'heure.
I thought we saw the document just now, just before this one. It was a table. I believe that was it. Did we see that again?
I'll go to R51 in 1 second, but before we leave your witness statement, do you agree that you testify you left the notice about the amount owed for this debt that had to be paid immediately or in order to avoid seizure of assets, that you provided it to the administrative assistant you refer to in paragraph 10 as Shima? Do you see that? If I could ask FTI to go back up to paragraph 10.
Je peux revoir le document que j'ai transmis?
Can I see the document that I? Yeah. Usually, when you are in contact with the company, well, the secretary receives the document, the notice. Now, it may happen that the secretary will not be certain, will hesitate, and will ask her boss to sign the document, but it is for the reception office, whoever is there, manning that office to receive and acknowledge receipt of the document.
And rather than hypothetically, I'm asking specifically because your paragraph 10 of your witness statement is specific.
Si je me rappelle bien,
Your testimony
Shema,
is that
c'était
the notice
le responsable
Mr. Pascal
de...
Shema was the secretary then.
Shema, c'était le
and you
responsable de
claim
Barbara.
that the document identified as R51 is what you gave Shima. Do you agree with that?
À travers Barbara.
I know it was through Barbara.
Can I ask FTI to bring up R51? That's the document you cite to and say in your witness statement at paragraph 10, you gave to Shima in order to provide notice to NRD as to the amount it had to pay to avoid seizure of assets, correct?
Oui.
Yes.
I could ask FTI
Well,
to,
I did give the document. The document was left at the reception. I mean, Barbara took the document, and Barbara in turn placed the document with her boss, whose name was Shima. But it was Barbara who took the document and passed it on. But indeed, it was Shima who signed the document, who signed not the document, but acknowledged receipt of the document.
if I could ask the FTI to scroll down so that the witness can see the full document. Do you see that the full document that you cite to are these 2 pages?
Oui.
That's correct.
You'll agree, sir, that the document you've testified that you provided to the company for notice of your collection efforts of this claimant, Mr. Pascal, did not attach any judgment in favor of Mr. Pascal. It's just these 2 pages, correct?
C'est marqué dessus que...
Well, it says so. There's a reference to the judgment. All the judgments and the rulings are referred to on that document.
And you'll agree that you didn't give a copy of the judgment. You gave these 2 pages. That's your testimony, correct?
Les documents étaient en annexe.
They were annexed, the document. They only signed the first page, the cover page.
But you didn't provide your copy of the notice that includes any
Tout
attachment.
était en annexe. Tout était en annexe.
Well, everything was annexed.
Sir, you kept your own copy of what Shima signed, correct?
Je garde les originaux.
I keep the originals and I produced photocopies.
And your
Because the-
testimony, I'm sorry, I didn't mean to speak over you.
Non.
Go ahead.
Your testimony in paragraph 10 of your witness statement is this is a copy of what you left with Shima, correct? You said that.
Mais chaque fois en annexe, il y a les copies de jugement.
Yes,
Well,
but
that's
every
Not a
time
fair
the
characterization
annex-
can I just interrupt? That's not a fair characterization of the witness statement. If he's going to tell him what's in his witness statement, Mr. Kelly must do so accurately. There's no inconsistency between what the witness is saying now and his witness statement.
I strongly object to the coaching. I showed the witness his statement. He's perfectly capable of answering this question. I believe it's fair. Sorry, sir, we spoke over. Do you have an answer?
Sur quelle question?
on what question, sorry?
The copy, excuse me, the document you put forward in support of your statement that you gave notice to the company that Shima received notice only includes these 2 pages. You did not provide a copy of a document that includes any judgment attached to these 2 pages, correct?
Dès qu'il y a un commandement de payer,
Well, as soon as there's a command to pay, you give the original, and in annex, we indicate the rulings that are to be executed in should the company or the legal representative disagree with what is written on the commandment to pay.
And
Then the company can produce a letter of protest, but that never happened.
And the reason, sir, there's no annex to the document designated R51 is because there's no annex to the copy of the original in your files, correct?
j'ai donné les photocopies sont toujours en annexe.
Well, the photocopies are always annexed.
Pour dire que tu exécutes le jugement numéro
To say that I am to execute the ruling so and so, you have to attach a copy of the rulings. Should the person who lost the case declines to execute, that person can challenge the accuracy of the ruling, but that was never challenged. That never happened.
So you'll agree that there is no copy of the judgments produced in support of your witness statement at paragraph 10.
J'ai bien écrit ces
And
2
you can,
pages.
bring back the witness statement, so
En
I don't
annexe,
want him to be misled.
il y a toujours le
I did say that well, in this document, you always say that in annex, the rulings are there. These documents are annexed just to prove that we're not fabricating this.
But they're not in the document you attached to your witness statement. That's all I'm asking you, sir. You can't agree with that? And again, if I could ask FTI, bring up the witness statement so he doesn't have to answer this question without seeing it. Thank you.
Il y
I
a
can't tell. if-
automatiquement les annexes du copie de jugement.
No, well, automatically the rulings must have been annexed, but you can be happy with producing just the 2 pages. But when you serve a demand, you produce a letter with the signature of the bailiff, and an annex to that letter, you include the photocopies of the rulings themselves, the rulings that are to be executed.
Sir, can I ask, when you prepared your original witness statement, you understood that one of its purposes was to establish for this tribunal that you complied with Rwandan law in everything you say you did to collect judgments against NRD?
J'ai exécuté en fonction de la loi.
Well, yes, I executed according to the law, and Mr. Marshall took me to court about at least 10 times, and he never won. Never won any of his lawsuits.
I'm going to ask you again my question, and I'm going to ask you to focus on what I'm saying is the purpose. I'd like to make sure we're in agreement that you understood when you prepared your witness statement that your purpose, one of your purposes, was to explain to the tribunal that you complied with Rwandan law in what you did to collect judgments against NRD.
Non, je n'ai pas à montrer au tribunal ce que je
It is not for me to establish what I'm doing. What happens is in Rwanda, bailiffs are independent. The bailiff stands in his office. When he receives a copy of a ruling, he then drafts a demand, and I don't have to, well, unless I'm being sued to say that I didn't follow the procedure, well, then there's a lawsuit. But in this particular case, the person who won the case went to the bailiff. The bailiff served a demand to pay. That is passed on to the company. And that's what I did here. It took these 2 pages, the 2 pages with the in annex, the copies of the rulings referred to on these 2 pages.
Sir, your witness statement in paragraph 11, which then goes on to the next page for a few more paragraphs, describes the seizure of minerals at Mineral Supply Africa in the name of NRD to collect on Mr. Pascal's judgment, correct?
Oui.
That's correct.
And please scroll down so that he could see the page. And Mr. Pascal, I'm going to ask you if in order to answer this question, you need to look further at further paragraphs above or below in your witness statement, please say so, and it will happen. My question to you, sir, is do you agree your witness statement doesn't provide any evidence whatsoever of your providing a statement to either Mr. Pascal or NRD as to the amount received at the auction and how much was credited against his debt?
Vous parlez de la vente aux enchères?
You're referring to the auction?
Yes, sir.
Tout le rapport est fait.
Well, a report was drawn up, and immediately after the auction, Mr. Marshall convened me to the police station, and it all happened in front of at the police station to say how the auction went.
Sir, that's not discussed in your witness statement, is it?
Vous m'avez pas posé la question.
Well, I wasn't asked, but marshal dragged me to the police station about 10 times, and every time I had to give explanations in front of the police officer.
And you talk about all the various times that you did recall when writing your witness statement that there were challenges and what you had to do to overcome the challenges. But you don't say anything in your witness statement about being drawn to the police station following the auction of minerals in NRD's name at MSA sold to pay Mr. Pascal's debt. Do you?
Mais chaque fois sur les documents, c'est marqué dessus.
Well, on the documents, it's always the reference is made to that. All you have to do is go through the documents. You'll find the references.
Sir, I asked you about your witness statement. Please just answer the question I asked. You'll agree you did not recite such fact of being drawn to the police station after this mineral auction in your witness statement. Correct?
On peut regarder en bas de la page.
Maybe if you go to the bottom of the page,
Le document original, ce que moi j'ai
FTI, please.
the documents that I drafted. Okay. Very good. Sorry, I overlapped a bit.
Please answer the question.
J'ai dit que chaque fois que je faisais mon rapport,
I said that each time I made my report, I wrote down at the bottom of the page to whom it was addressed. Each time it was written at the bottom of the page on my report on the auction.
Sir, I'm asking about your witness statement. Do you understand that?
oui, je comprends.
Yes, I do understand.
Okay. Can you agree with me that your witness statement doesn't say after the auction was held of the minerals at MSA, you were called to the police station and had to fill out such a report? Does it?
Dès que la vente aux enchères
As soon as the auction took place next to MSA, the next day, Marshall initiated legal proceedings against me, and I went to provide an explanation. In the report, it is said that that was done.
Can I ask a question? Are you able to read your witness statement written in English?
Je maîtrise le français mieux que l'anglais.
I speak French better than I speak English.
But are you able
If
to
you read me in French, I will understand.
the interpreter can tell you in French what I'm saying in English, but I don't have a written translation of this witness statement to French. I'm just trying to establish, when I point to something in this witness statement written in English, are you able to read it?
Non, pas correctement. Je préfère.
No, not correctly. And I prefer it in French. I understand the nuances, but I really don't speak English well.
I asked Respondents Council, is there a version of this witness statement in French that was signed off on before or after the English version was prepared?
Well, I will need to take instructions. I can't answer that now.
Mr. Cowley,
Yes,
whether something is or is not in the witness statement is a matter of record, of something that we can all see. It might shorten the cross-examination if instead of asking the witness to agree it's not in the witness statement, to ask, why did you not put this in your witness statement?
I appreciate that. I wanted to confirm whether he could check in it.
Yes, well, it's taking a very, very long time without any result.
Thank you, Your Honor. Mr. Nsi Guiuma, I'm sorry, sir. Can you explain why you did not attach to your witness statement any report given to the creditor, Mr. Pascal, or NRD, the debtor, as to the results of the sale of minerals and how much debt, if any, remain owed to Mr. Pascal?
Dans le rapport final, ça se trouve.
This is in the final report.
Can you explain why you did not attach such a report to your witness statement, sir?
J'ai donné un document de
I gave a document of about 100 pages. Everything I did, my work report, it's a very large document, about 100 pages long, and it's in there.
So do you agree that you gave all of the documents in your possession that related to your actions concerning the collection on behalf of Mr. Pascal to the respondent when preparing your witness statement?
J'ai tout le document, j'ai tout remis le document.
I gave the whole document. And everything that I did was in that document, but in my own language, Rwanda.
You are on mute, Mr. Cowley.
My apologies. May I ask that paragraph 17 of the witness statement be brought up? Paragraph 17 of your witness statement, sir, reads, in early 2014, shortly after I had finished Mr. Rocker Enga's case, a group of 26 people, mostly former NRD employees, asked me to help them enforce judgments against NRD. The total amount owed to this group by NRD was Rwandan francs 85,761,624. Do you agree that it's your testimony you did not start working to collect any of the other employees' debts until after you had finished Mr. Rakirenga's case?
Non.
No,
J'ai commencé
I started Mr. Rwakirenga, that is Pascal Rwakirenga, and along the way, his colleagues received a copy of the judgments in their favor, so they came to see me and asked, while you're executing the judgment for Mr. Rwakirenga, would you please handle our judgments? And this is how the 26 people basically joined in to the group with Pascal Rwakirenga. So the two actually were handled at the same time.
Sir, if you use, when using the phrase finishing a client's case, by that, do you mean collected their full debt and your work is done?
Non.
No.
When you use the phrase finishing a client's case, what does it mean?
On exécute un jugement.
We enforce the judgment. And when there are cases that are similar, there's the case of Pascal Rwanda, who's asking for enforcement of the judgment against NRD. At the same time, the other employees are asking for enforcement of a judgment against NRD. The two cases get combined, get joined, and the enforcement done against the same person or company. So the objects were seized accordingly, and then will be paid out progressively, but at the same time. So it's not that we completely complete one case then to start on the second. If they're close, if they're similar, then we combine them, we join them.
Sir, please appreciate that I'm not asking you to speak about Mr. Pascal's case and the other employee's case right now. I'm asking you how you use the term complete a client's case. When you use that term, by completing a client's case, do you mean you've collected their judgment, there's no more work to be done?
Avec la première vente aux enchères, le montant de
With an auction, we had, the whole amount was not covered. We had to continue with the seizures to reach the full amount. And that was not done by me. It was done by other bailiffs.
And those other bailiffs would need to see a statement of how much was recovered at the auction and credited against the debt to know how much was left to be collected, correct?
Les documents sont disponibles.
The documents are available or were available. A bailiff, when he finishes with his work, then the bailiff who takes over where he left off. When I enforced the judgment for Mr. Rwanda, I was the second bailiff to step in. There had been a first bailiff who had sold something, and then I took over. Then a third bailiff carried on after me, and it's always on the basis of documents and on the basis of a copy of the judgment. And there's information, and NRD is informed as the process goes on.
The group of additional creditors related judgments against NRD, as you described them here as 26, included Mr. Benzingi, correct?
Y compris qui?
I'm sorry, can you mention the name again, including whom? I didn't understand the name.
Mr. Benzingi.
Lui aussi a amené son dossier.
He also brought his claim or the copy of the judgment to be enforced against NRD.
I could ask that the witness statement be scrolled down to paragraph 20. Sir, paragraph 20 of your witness statement says, on 9 June 2014, I wrote to NRD and made a formal demand that they pay Mr. Benzingi the Rwandan franc 16.3 million they had been ordered to pay to him in the arbitration proceedings. Do you recall saying that as part of your witness statement?
Oui.
Yes,
And that cites to document R63 in your witness statement cites to that in footnote 25. If I could ask that be shown to him. Mr. Benzingi, you agree that the document that you put forward in your witness statement as the notice of Mr. Benzingi's claim does not include a judgment?
C'est marqué R comme A 0017
it's marked, you see the number of the document of May 2nd, 2014. That's the judgment that was being enforced. You see the reference. And your
Yes,
interpreter's
sir.
apologies, I didn't hear the number of the reference.
Yes, sir. I see it referred to in the document. I'm simply asking, do you recall that when you gave the document you called notice of Mr. Benzingi's judgment, you did not give such document with a judgment attached to it?
Non. Automatiquement, ça se trouve en annexe.
No, it's automatically annexed.
I could ask, go back
As
up.
soon as you say judgment and you reference it, it is annexed. So if there's any possible challenge subsequently, you cannot simply give the number of a judgment without actually showing the judgment. You have to show the judgment. And that's annexed. The photocopy is annexed.
If I could ask FTI to go back up to paragraph 20, the witness statement. Your witness statement goes on that same day, I also wrote to NRD and Mr. Benzingi and made a formal demand for the amounts due to the 25 former NRD employees that I was also representing. I sent the demand letter to Mr. Benzingi as I understood that he was still a shareholder in NRD and therefore liable for its debts. Do you see that?
Oui.
Yes, I do.
Is that accurate? That's what you believed at that time? Mr. Benzingi was liable for the debts owed to the other 25 clients on whose behalf you were collecting?
J'exécutais les copies de jugement
I was enforcing the copies of the judgments of the workers that they held against NRD. And at that time, Mr. Benzingi was part of NRD. And NRD was to pay the amount of 6.3 million. 0.3 million.
Mr. Insi Guiuma, excuse me again. I'm asking you to focus on the statement that you served the demand relating to 25 other employees' debts on Mr. Benzingi because as a shareholder, he was responsible for NRD debts. Was that your understanding as you took actions in June 2014?
en juin.
In June Mr. Benzingi was part of the board of NRD. When I was there at NRD's office, Barbara and Mr. Benzingi were there. They were together.
My question, sir, was in June 2014, did you think Mr. Benzingi had to pay NRD's debts to your other 25 clients?
Non, pas Ben.
No, not Ben. NRD was to pay.
Please explain why it's included in your witness statement that you considered Mr. Benzingi liable for NRD's debts, so you served a notice of the amount demanded on Mr. Benzingi on June 9, 2014.
J'ai donné au secrétariat
I gave it to the secretariat, the administrative assistant, the whole dossier stating that NRD had to pay all of the workers who had not been paid. And Mr. Benzingi was a shareholder of NRD's. On the sheet of Rwanda Development Board, there are the officials of the company, and Mr. Benzingi's name is amongst those names as a shareholder.
Why didn't you
Mr.
attach?
Cowley, Mr. Cowley, could I intervene? Can you give us some assistance as to how much longer you're going to be with this witness, because you've already substantially exceeded the estimate, and I'm getting rather hungry.
Yes, sir. I do believe it's going to be an hour. That's why I asked.
Have we, will we have interpreters available until this witness is finished? Can you?
Mr. President, I do believe we have the interpreters for another hour. I can speak with them offline as to their availability.
Could you just inquire, because if they are
Thank
able
you.
to stay longer, we can have some lunch.
Thank you. If we could have an offline chat, that would be very useful. This is one of your interpreters speaking.
Yes, FTI, can you please paste me in a breakout room with the interpreters?
Certainly. Would everyone else like to go into the breakout room, or do you want to have everyone just stay here while you're in a breakout room, have an offline discussion?
I think just an offline discussion will be brief.
One moment.
Thank you.
May I ask the tribunal if it would be okay to take 2 minutes to try to run to the restroom while we're waiting?
It certainly would.
Thank you.
Thank you, members of the tribunal. I see counsel are also in, oh, I have a wrong view. Excuse me. Okay, I have conferred with the interpreters and they have a hard stop of 3:30 London time, which will give a half-hour break plus 1 hour remaining for cross-examination. But it is a hard stop at 3:30. We will have one of the interpreters leaving at 3 as was originally planned. And then there will be one interpreter who will remain solo for another half hour, and she cannot exceed a half hour of solo simultaneous interpretation.
Very well, we will adjourn now until 2:30 London time. That will give 1 hour for this witness to be completed, and the witness must be completed in that hour.
Thank you. Mr. Kaplan, could I ask you just to go into our breakout room with us for 2 minutes?
One moment and I'll sign the breakout rooms.
Go have lunch, I think. We can-
Mr. Kaplan, could you just make sure the witness understands he's got until a half-hour break?
Monsieur Bosco, Monsieur Saint-Guillaume, vous m'entendez?
Oui, je vous entends bien.
Voilà, on prend pause de 30 minutes en ce moment.
Et puis je reviens.
Oui, et pendant ces 30 minutes, s'il vous plaît, vous parlez avec personne à propos de cette affaire. Bien sûr, vous pouvez quitter la salle ou la chaise, mais vous parlez avec personne.
OK, d'accord.
30 minutes. 30 minutes. Oui.
OK, merci.
Merci, au revoir. Witness is ready.
The witness is coming in now.
May I proceed, Your Honor?
Yes.
May I ask that the witness, the first witness statement be brought back up and paragraph 20 again be highlighted? Mr. Guillaume, I want to draw your attention in paragraph 20 to the day that you're speaking to here, June 9, 2014. In this paragraph, you explain serving notice on NRD of the debt to Mr. Benzingi, and you talk about serving notice on NRD and Mr. Benzingi of the debt to 25 other clients. And if I could point out to you that in your witness statement, you say, I sent the demand letter to Mr. Benzingi as I understood that he was still a shareholder in NRD and therefore liable for its debts. And I hand delivered the second letter to the NRD office. Barbara, the secretary in the office, accepted the document but refused to sign for it. Why is no copy of a notice of debt owed to 25 other employees attached anywhere to your witness statement?
Mais là, il faut lire le commandement de payer que j'ai donné.
You have to read the order to pay that is referred to here.
My question is simply, why is no copy of this notice attached to your witness statement?
J'ai remis 3 commandements.
I gave 3 orders. The first to pay to Pascal. The second one to pay Mr. Benzinge. And the third order was to pay the other employees. These are different orders.